Welcome, students. In this second Module 1 lecture, I will be discussing the concept of undue influence. Like mental capacity, the subject of our first lecture, the language of undue influence is similar to everyday words and the ways in which we use them. But we need to remember that this term has a special and specific meaning in law. We're going to be learning that meaning today. Also similar to mental capacity, the law cares about situations in which one person unduly influences another because of the impact of that influence on a person's ability to form a true intention. An intention to enter into an agreement of some kind, to make an appointment, as with an attorney under an enduring power of attorney, or to confer a benefit on another by making gifts of different kinds, including gifts in wills. The way that undue influence acts on a person's mind to interfere with their ability to formulate specific kinds of intent is different from the ways that impaired mental capacity interferes with an individual's ability to formulate intent. And so we may have a situation where person X is capable of making a will, applying the Banks versus Goodfellow test that we discussed in Lecture 1. But if her gift to Y is the result of undue influence exerted by Y, that gift will not be valid because it is not a true expression. The law has traditionally distinguished between the approach to undue influence taken in relation to wills and the approach to undue influence that has been taken in relation to inter vivos transactions, or transactions made during the life of the testator outside of the will's context. In British Columbia, our most recent legislation has brought undue influence in relation to wills closer to undue influence in relation to inter vivos transactions and agreements and gifts by incorporating the presumption of undue influence, which we'll go on to talk about a little bit more in this lecture. Outside of British Columbia, however, the traditional distinction between these two approaches will remain. Today, then, we are going to start by talking about the approach to undue influence in the inter vivos context. We'll then discuss the special approach to undue influence in the wills context. This is the traditional approach. And then we'll speak briefly about the approach that WESA, the wills legislation in British Columbia, has taken to undue influence in the wills context, and how that approach has brought the two closer together and, in effect, bridged that gap. Later on in this course, when we get more deeply into WESA, we'll be looking at that provision in more detail, but we'll be introduced to it today. Undue influence may arise in relation to inter vivos gifts, agreements, or transfers of various kinds. Interestingly, the agreement to marry, we discussed last week how the mental capacity issue can be relevant in this context, has traditionally been excluded from an undue influence analysis. It may be that the law has concluded that everybody is under undue influence to one degree or another when they decide to marry another person. Of relevance to this course, undue influence may become an issue in the inter vivos context in regard to an appointment of an attorney under an enduring power of attorney, in appointment of a representative under the representation agreements we talked about last day, or in relation to gift giving of different kinds. And gift giving here includes creating a joint account or a joint tenancy where property and funds have been provided by one party only. We'll find that this kind of gift giving not infrequently arises in the will's context, where the estate seeks to have a gift made inter vivos during the life of the testator set aside on the basis of undue influence and thereby returned to the estate. Although undue influence may certainly arise in relation to appointing a representative, it is especially likely to arise where property and finance are concerned. The English courts have set out the framework that I have set out here on this slide for organizing and articulating the traditional approach to undue influence in the inter vivos context. I like this taxonomy, and I think that it's a very useful way for understanding how these different species of undue influence, as the English courts refer to them, relate to one another and also are distinct from one another. This framework or taxonomy reflects the law relating to undue influence in Canada. I refer to this as a framework developed by the English courts. By this I mean that it's the English courts that have set it out in this particular very clear way, using this language of type A and type B. But in doing so, the law that they describe here is the approach that the Canadian courts have taken, just maybe without this lovely clear framework and taxonomy. So within this framework, two species or types of undue influence are identified. The first, the English courts call actual or overt acts of undue influence. And the second is presumed undue influence, which means undue influence that is presumed to arise from the nature of the relationship between two individuals, where one of those individuals confers a benefit on another. Actual undue influence generally takes the form of overt manipulation, threats, pressure, is evident to the onlooker. Presumed undue influence refers to a presumption where there is a relationship in which potential for dependence arises from the nature of the relationship itself, where one person in the context of a relationship of that kind confers a benefit on another. The law will presume that the reason why that benefit was conferred is because of undue influence exercised in that relationship. Now, because this is a presumption, of course, remembering the nature of the presumption, presumptions can always be displaced. So the person taking that benefit can always displace the presumption by bringing some evidence that establishes, the reason why this other person gave me this money, gave me this property, conferred some kind of benefit on me, was because they really did truly intend to confer that benefit on me. And it was not the result of the undue influence that I exerted through that relationship. Now, there are different ways of proving that this gift was the result, or benefit of some kind was the result of that person's true intent and not undue influence. Of course, one of the best ways of proving this is by showing that the individual received independent legal advice before proceeding to confer that benefit. But other kinds of independent advice and discussion with trusted friend or spiritual advisor, but crucially not in the presence of the person that would take the gift, may also be sufficient to displace that presumption. The key here is that at some point in this decision-making process about whether to confer the benefit onto another person, the giver of that benefit had an opportunity to step outside of that relationship, talk to another person who was outside of that relationship, and in fact whose interests were aligned with the person that would be giving the gift and not with the person that would be taking the gift. So if the gift giver has that opportunity to speak with that other person, discuss the situation with that other person, and receive some advice from that other person, and then makes the decision that they wish to proceed, we can generally be satisfied that their decision to confer that benefit was true, was real, was genuine, was the product of their intent, and not undue influence arising within that relationship. So that's the concept of the presumption of undue influence. Arises from a relationship in which the potential for domination is inherent in the nature of the relationship itself. Once that relationship is established, the presumption of undue influence is raised, and then it's up to the person that takes that benefit to displace the presumption. Now, within that category of relationships that will give rise to a presumption of undue influence, there are two subtypes. So the first of these within this taxonomy is identified as type A. And these are relationships that will always give rise to the presumption. So one of these is lawyer-client. So we presume always that in a relationship of that kind, because of the formal rules of the parties, that it is a relationship in which there is a potential for domination of the lawyer in relation to the client, the lawyer being the dominating party. And so that means if in the context of that relationship, the client confers a benefit on the lawyer, gives them a gift, for example, before taking that gift, the lawyer should take steps to assure her or himself that this gift reflects the true intent of the gift giver and not the undue influence that arises because of that relationship. And so before taking the gift, the lawyer needs to suggest that the person receive independent legal advice and be satisfied that the individual has actually done so. So that's a type A relationship. Always gives rise to the presumption because of the respective rules of the persons in that relationship. Now, a presumption of undue influence might also arise in a relationship that we could call a type B relationship. And that is where the dynamics of the particular relationship give rise to the presumption. So the courts have described this as requiring a meticulous examination of the facts to see what was the particular sort of power relationship or power dynamics in this relationship. And then the question is, does this relationship create a potential for domination inherent in the nature of the relationship itself? And if yes, then we will say this is the kind of relationship that will give rise to a presumption of undue influence. So type A relationships always give rise because of the nature of that relationship as a category. But if it's a type B situation, we look at the nature of the very particular dynamics in that factual situation and say, in this relationship between this people, because of the interpersonal dynamics involved, or perhaps relationships in one person is dependent upon another, do we say that the presumption has arisen? So I'm going to give you an example of one of these type B relationships, illustration that might sort of help you to get your head around this a little bit. It's a case that's called Z versus Z. And here we had a elderly mother who had some property. She didn't speak any English. This was in Canada, and she was completely dependent on one of her sons for pretty well everything. So he kind of acted as her translator to the world and took care of her business affairs for her, took her to all of her appointments and so forth and so on. Now, in the context of that relationship, the mother gave one of her properties to the son. And so now the question was whether, because there was a presumption of undue influence arising in that relationship, the son now had to establish, had the job of proving that, yes, my mother really did truly intend to give me this property. And here's the evidence I have establishing this intent. So that's an interesting case because there was no malicious intent on the part of the son. He wasn't manipulating. He certainly wasn't threatening. In fact, he was kind of behaving like the paragon of the good son. But if we look at the particular nature of that relationship, it was a relationship of extreme dependency in which the mother was extremely dependent upon her son. So it was a relationship in which there was a potential for domination inherent in the nature of the relationship itself. So before taking that gift in the context of the relationship, it's really the responsibility of the relatively more powerful party to take steps to satisfy themselves that this is an expression of the other person's true intent. Sometimes when I talk about presumption of undue influence situations, I know that students' first instinct is to think this is very unfair, especially when they hear the story about really the dutiful son in that case of Z and Z. But remember, the presumption of undue influence arising from a relationship is just a presumption, and presumptions can always be displaced. And as we've discussed in this situation, the presumption is displaced by showing that, yes, this truly was the intention of the individual and not the consequence of undue influence. So that's what we're concerned with, is real proof of that intention. So there's no magic formula. We can't say that independent legal advice is always what's required. I say it's certainly a good way of establishing that. But we may have other kinds of advice that are available as well that provide some evidence that can satisfy us that, yes, this really is an expression of the person's true intent. And that's really what we're looking for here. If the presumption is not displaced and it remains, then that gift will be set aside on the basis of undue influence. Why? Because that requirement of intent will not be present. So remember, in our first lecture, we talked about the importance of intent in all of these contexts that we're talking about here in order to effect a valid gift, a will, an appointment, a transfer. That intent requirement must be present, and undue influence, where it exists, and that means in a presumption situation where the presumption hasn't been displaced, will vitiate intent. So I've been talking to you about the traditional approach to establishing undue influence in inter vivos contexts. And so remember, inter vivos means during life. And of course, there are many inter vivos contexts, sort of all agreements and transactions and gifts that are taking place within the scope of the individual's life. Now, traditionally, as I mentioned, there has been a special different from the inter vivos context approach to establishing undue influence in the testamentary context, and that means in relation to wills. So where the testator has died, and now somebody comes along and challenges the will and says, "Oh, this will was not a valid expression of testamentary intent. This will was actually the result of undue influence." So traditionally, the only way in which a challenger could succeed in having a gift or even the entire will, where uh, relevant, where suitable, set aside on the basis of undue influence, is where the challenger could prove type A undue influence, referring to that taxonomy I had set out on my earlier slide. So that was the job the challenger had. This means the challenger could not say, well, this is a situation giving rise to a presumption of undue influence. And so now it's the job of whoever is trying to assert that this will is valid to prove that, yes, it was actually the true intent of the will maker. So that was the traditional rule, that whoever wanted to challenge on the basis of undue influence had to bring actual evidence before the court establishing undue influence. So there had to be some kind of evidence of behavior that would constitute undue influence. As you can imagine, one of the consequences of this traditional rule about undue influence in the testamentary context was to make undue influence very, very difficult to establish. Because behaviors that would constitute undue influence are generally not carried out in front of other people or through methods that would provide evidence about what was happening in that situation. So this is one of the reasons why WESA, the wills legislation in British Columbia, in what was really a very radical move in the law of wills at the time, decided to alter this by really importing that presumption of undue influence mechanism that we've just been talking about into the legislation. So Section 52 of WESA now essentially codifies that presumption of undue influence that we've just been talking about. So now, if somebody wants to challenge a will under WESA, they could do it two ways. If they have evidence of undue influence being exercised over the will maker, they can bring that evidence before the court. And if it's sufficient, if it's compelling, undue influence will be found, and the gift or even whole will, if applicable, will be set aside on that basis because of the impact of undue influence on testamentary intent. So that remains possible, but now because of Section 2, the challenger can also establish that, yes, there was a relationship here in which there was a potential for domination inherent in the nature of the relationship itself between the will maker and the person who would take a benefit under this gift. And if the challenger can prove that, then the onus then flips to the person trying to prove the will is valid, right? Asserting that no, there was no undue influence, to show that actually this gift was an expression of the will maker's true intent. So again, when we talk about WESA in more detail, we'll be looking at this more closely. So we've been talking about the context in which undue influence can arise. And we've been talking about the different ways in which undue influence can be proven, either in the inter vivos context or in the testamentary context, But what is undue influence in terms of content? And there are many interesting descriptions, certainly, of undue influence in the cases. And I feel that the best way to really understand undue influence is to read the stories about undue influence in the cases and the descriptions of the different kinds of relationships in which undue influence has been found to arise. So I tried to give you a little taste of that by giving you the story of Zed versus Zed, about the older lady and her son on whom she was extremely dependent. And so if you look through the cases and really pay attention to those stories and some of the nuances in them as well, that's really the only way in which you'll, I think, get a really meaty understanding about undue influence. But here's a nice description of it that originates with this 19th century case of Wingrove versus Wingrove. Many of these Wilson Estates cases are quite ancient in origin, but cited fairly recently in Elder Estate versus Bradshaw. So it describes undue influence as coercion. So this is nice, I think. If the testator, so the will maker, has only been persuaded or induced by considerations which you may condemn, really and truly to intend to give his property to another, even though you disapprove of it, it would still be legitimate. So what the court is saying here is just emphasizing this is about the nature of the testator's intent. That's what we're worried about. We're not worried about whether we like the reasons why the testator did this or not, or whether we approve of them. What we're concerned with is their ability to formulate true intent, and whether that ability was impacted by the influence of another person. It is only when the will of the person who becomes a testator is coerced into doing that which he or she does not desire to do that it is undue influence. So here Wingrove goes on to give us what I think is some very useful further discussion of the content of that coercion, what that coercion looks like. So the coercion may, of course, be of different kinds. So it may be gross, such as actual confinement or violence. And that might be what usually pops into our mind when we hear that word coercion. But a person in their very last days or hours of life may have become so weak and feeble that very little pressure will be sufficient to bring about the desired result. And it may even be that just talking to him at that stage of illness and pressing something upon him may so fatigue the brain that the sick person may be induced for quietness' sake to do anything. Just basically, just shut up, just stop going on about it, stop talking to me about, yes, I'll do it. So that is also coercion, even though it's not actual violence. And that may be less like what we usually think about when we hear that word coercion, but actually coercion in the will's context is more likely to look like this latter kind than the former kind, actual violence. And the case goes on to say that depending on the individual situation, very little pressure may be needed. And that too forms coercion. So in these presumption situations, we've talked about how the key question is whether the relationship itself gives rise to a potential for domination. And those relationships can be of many different kinds if it's a type B situation, as we've discussed. But relationships of dependency are one type of relationship that's particularly likely to give rise to the presumption. And of course, that's the situation in the case of Zed versus Zed that we discussed. Why is this so, you may ask? Going back to the story in Zed versus Zed, you might say, well, surely the mother in that relationship was the stronger player, because she, in essence, had the son really doing everything for him. The court there really looks at the relationship, the details of that relationship, and finds that, in fact, her extreme dependency on him meant that her fear of losing that support is the quality that is the domination that's inherent in a relationship of that kind. So again, it's not that the son is actively or even intentionally trying to exert dominance over his mother. It's rather that the dependency dynamics in that relationship themselves do create this domination through the fear of losing that support. And it's for that reason that the more dependent person becomes induced to make a gift that otherwise she would not, which is really the essential characteristic of coercion in this context. So the policy argument here is that it behooves the relatively stronger person to be the active one, to take the steps, to be looking out for the dependent person and say, thank you very much. I really appreciate that, but I want to be sure before I take this that this is your true intent. So I'm introducing you to the concept of undue influence as one of these initial core concept lectures in Module 1, because undue influence arises in the context of wills and estates, certainly, and also in the incapacity planning context that we're going to be talking about in this course. Issues of money and property are, of course, engaged here, as they are in the same context with relation to mental capacity. Also, as we discussed in our lecture number 1, dealing with mental capacity, relationships involving dependency of the kind that were discussed on the previous slides may also be a factor for persons who are making wills or incapacity planning instruments of different kinds, who may be experiencing health declines, either physical or cognitive or both, and those health changes may in fact be providing their motivation either for making their will or for engaging in incapacity planning. So those factors may well involve relationships of dependency that may involve undue influence of different kinds, either more overt and intentional kinds, or kind of subtler forms of undue influence that arise from the nature of the relationship itself. So for this reason, undue influence is always something that we have to be alive to, alert to, and aware of in this context.